I'm Bridget Wagner. I direct Coalition Relations here at the Heritage Foundation. And Michelle Easton, who's your normal first half host, is actually stuck in traffic, and I'm assuming it's the cherry blossom. She called probably 20 minutes ago from the bridge in a panic. She thought she was going to be here. And I know Karen Harned has a hard departure time to go do a Megyn Kelly taping. So we want to make sure that she gets out the door and can tell a great story about our topic today for all the Fox television viewers. So today the topic is Obamacare. As you all know, this is the second anniversary of the signing into law of perhaps one of the most important pieces of legislation in our lifetime. It's going to be a power grab, as we have seen, on the scale that I think we haven't yet experienced in this country. It's not just a fight over health care, as we have argued here at Heritage, and I think has really inspired the Tea Party community and the grassroots, and it's why we're seeing the public opinion polling so strongly in opposition, that this is not just a health care issue, it's a question of our freedom and who is going to be in charge of the most important decisions we make or want to make in our lives about our health care and how we live our lives. So today we have an awesome panel who are all incredible conservative women leaders. And we have a member of our healthcare team, the leader of our healthcare team here at Heritage, Nina Owchenko, to introduce them. So I'll turn it over to Nina at this point. Welcome, Nina Owchenko.
Well, thanks so much. And just to kind of give a little bit more perspective on what this day is all about, 2 years ago today, the President signed into law his signature legislative victory, Obamacare. The health care law that then Speaker Nancy Pelosi said we had to pass it to learn what was in it. Well, what we've learned shouldn't be a surprise to anyone at this point. The health care law remains unpopular among the American people. Recent poll shows that 56% of Americans want the law repealed, and 46% of that 56 strongly believe it needs to be repealed. So they're not even wishy-washy. They're clear. They want it gone. While the full thrust of the health care law really doesn't take place until 2014, even the small provisions that are in effect today really underscore and show how ineffective and unworkable this law is going to be in the future. Finally, the upcoming Supreme Court arguments against the law further underscore that the health care law is not settled business. Today we have, as Bridget said, an excellent panel of speakers. I'm going to do real quick introductions of them so you get a gist of who they are and then let them speak. Karen Harned is the Executive Director of the National Federation of Independent Business, Small Business Legal Center, and is the lead on the NFIB's case against Obamacare. Next, we have Carrie Severino, who is the Chief Counsel and Policy Director at the Judicial Crisis Network, and most notably was the author of 3 briefs on the case, 2 on behalf of 2 groups of senators, and the other on behalf of Speaker Boehner. And finally, we have Hadley Heath. She's the Senior Policy Analyst with the Independent Women's Forum, and a great organization that has really been on the forefront of educating the public on the consequences of the health care law. I should note that Christy Herrera with ALEC, the American Legislative Exchange Council, was scheduled to be with us today, but she had a family emergency, so she won't be joining us. But let's welcome our speakers, and let's bring Karen up.
Well, thank you for having me, and thank you to Heritage for all they have done to support this effort that we've been undertaking here for 2 years. And also, I have to thank Carrie and Hadley, too. All of these organizations, it's very much been a team approach, and hopefully to victory. So the right to be left alone is indeed the beginning of all freedoms. This quote from Supreme Court Justice William O. Douglas could have just as been easily written by one of the 350,000 small business owners NFIB represents across this country. One of my first memories of running our legal center was a speech that our CEO gave regarding small business. He channeled small business owners across the country as he talked about their entrepreneurial spirit and, more importantly, their freedom. Their freedom to own, operate, and grow their business, and their freedom to put a sign on the door saying, "Gone fishing." Indeed, as this country works to get back to better times, it's the small business owner that holds the key. After every recession, small business has led our country to recovery. But as you can imagine, over the last several years, small business owners have been repeatedly asked, what can the government do for you to help you create jobs? The answer is as uniform and straightforward as the gone fishing sign. Government, they say, needs to get out of our way. Yet here we are on the eve of a momentous occasion in our nation's history with small business leading the way. Our founding fathers fought a revolution to secure the rights of individuals to be free to pursue their own lives and enjoy the rewards and the consequences of their personal choices. They believed so greatly in the principles of liberty that they risked their lives and their fortunes for a free America. Upon securing our independence, they sought to protect our liberties by enacting the Constitution with the explicit purpose of limiting the powers of government. They believed that by limiting federal power, they were preserving our individual rights and ensuring our future prosperity. But in the past century, our Constitution, the freedoms our Constitution affords all of us, have been chipped away bit by bit. The federal government has become that great Leviathan that the founders feared, as it now seeks to meddle in every aspect of our lives. That is why we are here. It is time to turn back the tide and to reclaim our liberties. It is time to reaffirm that there truly are limits to the government's power over all of our lives. And that is why NFIB joined the legal challenge to the healthcare law. 2 years ago, healthcare challenges were openly ridiculed by supporters of the law as frivolous. But today they are anything but, with the Supreme Court devoting 6 hours of oral argument time to these cases. This is the most time the court has devoted to oral argument since the landmark cases of Brown versus Board of Education and Arizona versus Miranda. In addition, they ordered full briefing on 4 separate issues: the individual mandate, severability, the applicability of the Anti-Injunction Act to these challenges, and the impact of the expansion of Medicaid on all the states' 10th Amendment rights. The healthcare law has 2 primary goals: to increase health insurance coverage and to decrease health insurance costs. To increase coverage, among other things, Congress chose to provide below-cost insurance to sick people. But that alone would hurt the goal of lowering costs. As a result, Congress adopted the individual mandate, which forces healthy people to purchase above-cost insurance in an effort to counteract the insurance regulations' inflationary effects on premiums. So the primary purpose of the mandate is not to regulate the uninsured Americans who are engaging in some harmful economic activity, like not paying their medical bills. Instead, the primary purpose of the mandate is to compel the uninsured into engaging in economic activity that is harmful to them but helpful to third parties. Our legal challenge is actually a humble one, a mere effort at defense. It's an easy opportunity for the court to reinforce the structural limits of the Constitution that help to guard all of our freedoms, but do so without disrupting any other laws on the books. By contrast, the government's defense of the law presents an enormous opportunity for unleashed governmental power. Small business owners know that the individual mandate is unprecedented, unlimited, unnecessary, and extremely dangerous. Unprecedented. This is the first time in our nation's history that we have the federal government requiring all of us to buy a product from a company and enter into a contract with that company. Even if you look at the dramatic expansions that occurred in the New Deal era, you find that Congress never went this far. Unlimited. After 2 years of arguments, one common theme has arisen as the government struggles to defend the individual mandate. The government has been unable to say where it would end and what product Congress couldn't force all of us to buy. Unnecessary. The individual mandate is not the silver bullet to keeping people from going to the emergency room and not paying for care they receive, or for saving the health insurance industry from new congressional mandates that would drive up their premiums and put them out of business. Using its taxing and spending power, Congress could have solved these problems without violating the Constitution and trampling on all of our liberties. Dangerous. As even the Congressional Budget Office admits, the individual mandate could produce, quote, a command economy in which the President and Congress dictated how much each individual and family spent on all goods and services, close quote. For small business, freedom is serious business. It's what motivated them to start their business in the first place. Always up for a fight, we know we have a tough one ahead. Let's hope we win.
Hello. I want to give a little bit of a legal angle on this, as Karen did a great job of outlining the background of what's going on with this health care law. And there's a lot of reasons why this law is very bad policy and why it's going to hurt our businesses and hurt individuals across America and, frankly, not do what the government claims it's going to do, which we're seeing even as the Office of Management and Budget is coming out with new findings about how much it's going to cost and how many people it's going to harm. But I think the most important issue here is that the mandate is in this law is unconstitutional. And if we look back at the reasons we have a constitutional government, I think we see the importance of this issue. Our founding fathers created a government of limited powers. Their reasoning in doing so is because they were coming from a tyrannical government, and they recognized a truth that I think we risk forgetting sometimes today, that any government run by fallible human beings does have a tendency to amass power to itself and to become a tyranny. The founding fathers felt that very strongly, and so they designed our Constitution specifically to combat that. The way they did that was, one, by dividing it into several different segments of government. You've got the executive, the legislative, the judicial, everything we learned in our civics classes, right? But in particular, they gave the government limited power. So we have a national government that only can do certain things. It doesn't have broad power over every aspect of our lives. In some extent, states have that power. But the federal government only has certain tasks allotted to it, things that really only a federal government can do well. Coining money, so you have a consistent currency, and maintaining bankruptcy laws consistently across the country. Raising an army, taking care of the navies, combating piracy, things like that, okay, it makes sense. Running the post offices. This is something that has to be done nationally. One of those limited and enumerated powers was the power to regulate commerce among the several states. It was originally conceived to prevent things like tariffs from one state to another, so you don't have all this trade fighting amongst the states and can have free and easy trade. This is the authority that the government has. And our founding fathers felt that as long as the federal government remained confined to these powers, it would be much less likely to take over every aspect of American life. Well, fast forward to 2010 when the law was passed and to where we are now, 2012. We have become, as a nation, very complacent about policing those boundaries in the Constitution. We have become more willing than our founding fathers were to accept the promises of the government. Well, just trust us. We can take care of this issue. This is something that the framers of the Constitution never would have believed. They knew that even while people are going to try to, say, elect a government that will have their best interests at heart, there's always the temptations to overclaim power. So just trust us was never an all right answer for them. This next week's arguments go to the heart of whether we, at the end of the day, have constitutional protections or whether we have a just trust us kind of version of government. Because the one issue that has dogged the litigators in this case throughout all the courts is the idea that their interpretation has no limiting principle. They're saying that the authority to regulate commerce among the several states now encompasses authority to make you buy health care. Let's see how far that has come. It started with some precedent that said, well, we can regulate commerce among the several states, so it makes sense if we can regulate, say, something that's being transported between the states. We ought to also be able to regulate that same thing being produced in-state because it really affects those markets as well. Okay, we'll take it maybe a little step farther. It doesn't have to really be among the states as long as it's affecting the commerce among the states. Then we have cases that say, well, even if it's not something that itself strictly is speaking is commerce, so for example, production of wheat. It isn't maybe commerce itself, but it really affects commerce because of the way it interacts and the thing. We'll let them regulate that. And so now we have regulating things that are almost commerce that almost go between the states. This is bad enough, but what we have come to today is the government making the argument that not only can it regulate things that affect commerce, that affects commerce between the states, but also it doesn't have to be a thing they regulate. We can force you to engage in commerce in the first place. So we've taken out the between the states, we've taken out the commerce, and now we're taking out the very word regulate from that sentence. So now it basically says the government can do whatever it wants having to do with commerce, even if you have to go through a whole chain of inferences to get there. I submit that there's no limit on that theory to what the government now can do. We've had people that are laughing at claims that the government can make you buy broccoli, can make you get a gym membership, but never has the government been able to articulate a reason why it can't. They can say, oh, they would never do that. Come on, even President Bush, the first, didn't like broccoli. We would never make you all buy broccoli or eat it. But the fact of the matter is, under their theory, the government could, because look, even if buying broccoli isn't interstate commerce, the broccoli probably came from a different state. Your health care is being paid for the government, and that's an interstate issue, and your consumption of fruits and vegetables does affect the interstate commerce, just as a butterfly's wings in China do affect the weather today and giving us such lovely weather. They're also making really extreme arguments about another clause in the Constitution, the necessary and proper clause, which is a catch-all in some way. It says the government can make laws necessary and proper to the execution of its other powers, but the degree to which the government has taken it is so far that, again, there's really no limiting principle on it. And if we accept their interpretation, if the Supreme Court does next week, then we will no longer have a limited government. They say that Congress had authority to make some of these regulations. It has the authority to regulate an interstate health insurance industry. It has the authority to regulate perhaps people who are already engaging in interstate businesses, et cetera. So it can make them provide health insurance for their employees. And so because it has authority to do these aspects, now it also has the authority to do something that's related to them. As Karen suggested, some of these the regulations will have hugely negative effects on the insurance industry by forcing them to take all comers regardless of their health status and have someone who is unhealthy and make them pay the same amount for their expected health care as someone who's in perfect health. That will have a horrible effect on the insurance industry if you don't then compensate it by providing a guaranteed revenue stream of having all these healthy young people into the insurance industry. So they're saying, well, if we can do A, then we can do B over here that helps us do A. And under that theory, the government literally can do anything because they can if there's a law they can come up with that they can do constitutionally that creates huge national problems. Now they have a wide open door to fix it, and they have a blank slate basically. So I think at the end of the day, the limiting principle on both the Commerce Clause and the Necessary and Proper Clause are going to be issues that the Supreme Court takes seriously, and they're issues that some of the lower courts were able to brush past precisely because they're lower courts, because they know there's going to be a backstop. But I hope this is something that the Supreme Court justices will take very seriously, because if they conclude the government is correct on either of these interpretations, then we truly have lost a fundamental feature of our government as the founders intended it. We've gone from a government of limited power to a government of trust me, we won't do that, and that is far from something our founding fathers certainly would not have recognized.
Hi, good afternoon. I'm Hadley Heath with IWF. I'm just thrilled to be here today with Nina and Karen and Carrie. These fellow panelists of mine are just the authorities on what's been going on in healthcare and in the Supreme Court case. So I hope you'll have your legal eagle questions ready for them during Q&A, because these are the people I take my questions to when I have them. So I've actually tried to step back from this Supreme Court case and from the Obamacare law in general and think about what it means for the long term. I'm pretty young. I'm hoping to live, God willing, at least 50 more years in this country. And since this is a women's event, I thought it would be appropriate to talk about the effect of this law potentially for the next generation and the next. I don't have any kids yet, but I hope my kids will reside in the United States, and I hope they'll have as great of an American experience as I have had. So the long term. How many of us know about Roe versus Wade? How many of us know about Brown versus Board of Education? These are some Supreme Court cases that everyone knows about. And I think HHS versus Florida is going to go on that list. In fact, I think it'll be even bigger. I think in the future, lawyers and judges will cite these decisions and plenty of other decisions about individual rights and about plenty of things outside of the field of healthcare. So we have two outcomes potentially. I mean, there's multiple ways it could break down, but ultimately the Supreme Court's going to uphold the law as it is, or they're going to do something to strike down part of the law or all of the law. So if upheld, it's particularly concerning to me about what this means for the future of individual rights and the limits of government. Young people, people in my generation, supported the election of President Obama by about 30 points, and when the Affordable Care Act passed, we supported it by about 13 points. So we were pretty excited, I think mostly because of the stated goals of the legislation, that we're going to expand health care coverage in the United States, and people with pre-existing conditions would be able to purchase health insurance. But I'm afraid that, as we are seeing now, some of the most touted and most popular parts of the law will not turn out to be as great as we thought, and the more negative aspects, the cost of the law and the damage, potential damage to individual rights, is going to be greater than we anticipated. As Carrie pointed out, one of the greatest American ideas about government in all of history was that we would have a government of laws and not a government of men. We would have a government where it would be slow to change what's on the books, that the priorities of the majority of the people or the priorities of our civil society or culture would not automatically be adopted and forced onto other people by law. So even though I think millennials and young people and women generally favor President Obama as a leader more than other segments of the population, it's important to remember that he won't be the president forever. We won't always have the same people in Congress, and you know, maybe we're happy about that. But at the end of the day, when we give power over to the men or women in government rather than sticking to the law, we're playing with a very dangerous precedent. And as Carrie said, it's not about what government would do, it's about what government could do. And I think we've seen, especially since the more recent regulations about contraception, that government abuses of power are very hard to foresee. 50 years ago, I don't think anyone would have anticipated that the government would be forcing some people to subsidize contraception use by other people. And 50 years from now, who knows where this is going to lead us. So it's very important to emphasize the loss of liberty aspect of this law. But one thing I've seen in public policy is that when you're right in principle, you often see the results in the practical. And so far, we've seen the CBO revise its cost estimates a lot higher. We realize that we're trying to solve a cost-shifting problem in healthcare with more cost-shifting, and we're increasing the amount of healthcare dollars that are used that are really someone else's money. And we all know that when you're paying with someone else's money, you're not as responsible. So there's a loss of individual rights, but there's also an encouragement to lose our individual responsibility piece in healthcare as healthcare consumers. And economically, specifically, again, for young people, this is going to be disastrous in terms of our health care costs, especially health insurance premiums that, because of community rating laws, will skyrocket. And also, I think that the Affordable Care Act has also introduced some more damaging aspects to the culture surrounding health care. I think it is important to remember that at least so far, the American culture has been friendly to the idea of live and let live. I don't care if you want to go have a cigarette on your smoke break. That's your business. You know, maybe if you're a close friend of mine, I might tell you that that's not an advisable health choice. But at the end of the day, you know, you're paying mostly for your own health care. But when this law kicks in, there's going to be a lot more shared responsibility, shall we say. So the shared responsibility in healthcare really does make it so that there's no such thing as my business anymore. As we saw again with the contraception mandate, nobody wants to have to explain to their employer what's going on in their sex life. Nobody wants to have to explain what conditions they may have, because that might change the formula for whether or not they get hired. And it's very important to remember that if you want something to be your business, like your personal business, then it's also your responsibility. And so I think that the Affordable Care Act is not only damaging constitutionally speaking, but economically speaking and culturally speaking. So today, we've been talking about the Constitution a lot, and I think it's important to emphasize that the Constitution is not just words. I think President Obama has said before, don't tell me that words don't matter. And he was right. It matters whether you call it a tax or whether you call it a mandate. But the Constitution's not there just so that we can follow it because of our love of tradition in the United States. It's there because the principles behind it make sense. And I would hope that future generations of Americans would continue to value the Constitution, not because it's been here for 200 years, but because ultimately it makes sense when you apply laws that are within its framework. That's all. Thank you.
Well, I think the one thing we can say is this debate, if there's anything good that's come out of the health care law, is it maybe has re-inspired people to look at the Constitution and remember what this country was founded on and what we want to see our future for today's generation, but also what we're leaving for other generations to come. I know Karen has to leave soon, so if anyone has a quick question that's directly related to NFIB, if you want to raise it now, or forever hold your peace. So identify yourself if you'd like.
Laura Truman with the Heritage Foundation. My experience with small business people is that they're very busy. They work really long hours, and their focus is on growing their business. So to me, it would take quite a bit to rouse their attention from that immediate task and decide through their national organization to get into this. I also find that they don't really enjoy getting into the political arena so much. So I wonder if you could tell us a little bit about the decision process to take this very high visibility step. It costs a few dollars, I would imagine, too. And how you vetted that with your members, if there was reluctance, just a little bit about the thinking behind that.
Right. No, thank you for that question. Yeah, that was an intense time, and it really started. My life changed that Monday when we came in after the Senate had passed the law, because the phone started ringing. We have, you should understand our structure is we've got lobbyists in all 50 states, plus we still sell door to door, so we've got sales reps in all 50 states, and I mean to tell you, they were like, they want to know what you're going to do about this. And our VP of policy said, you're up. And I was like, okay, let me go figure this one out. And I mean, but seriously, why were they so energized? Well, health insurance costs have been their number one issue since, I think it was 1986. I mean, it's been over 2 decades, because they on average pay in the small group market 18% more than people in that work employers or unions pay, or the government. 18% more, just right off the top. And so they looked at this law and they're like, okay, take that can of kerosene out and just put that on the fire, and now my costs are going to go up even higher. So it was funny because anybody, we do try to get out there, right, from D.C. And so anytime anybody came back from to D.C. from going out and visiting our members, those first couple of 3 weeks, they were like, okay, I was there to talk to them about taxes, but all they wanted to talk about was, what are we going to do about this healthcare law? So bottom line is, we were hearing from our members. We did do some reach out to them, too, to just confirm what we were hearing, which was by, I don't want to say unanimous, because we do have some members that disagree, but by a significant, strong majority that we didn't have to worry about, let's put it that way. They wanted us to enter this fight, and we knew it was going to be a big deal. I mean, for NFIB, this was a huge deal. I mean, Laura's been here. I mean, so does Bridget. I mean, this was a big deal for NFIB because lobbying is one thing, but they, I don't know if we want to do this big court case. But, I mean, at the end of the deal, they knew that's what we had to do. We had to do it for our members. And what have we seen as a result? confirmation that we did the right thing, because our membership has grown over the past 2 years, and that's the first time that's happened for NFIB back-to-back in 20 years. So, we must have done something right. I know we've made people angry. I get those emails. But we've also made a lot of people happy. And I think at the end of the day, again, we did what we had to do for small business. Because I remember, one just other quick note, I remember our tax counsel coming in, and he'd just seen a program, Monday after it had passed or something. And some woman from Oppenheimer Fund said the two biggest losers in this law are small business, and I can't remember who she said the other one was, but small business was our first one. And I was like, that's exactly right, because they've made a bad market worse with this law.
I wonder, Karen, if you can tell us, Bridget Wagner from Heritage, about the plaintiffs, the NFIB plaintiffs, and how were they selected, and what's their situation, and how is this going to apply in the court?
Right. Well, so we have 3 plaintiffs. We have Mary Brown, who you have seen articles about, and she's lived, as many small business owners, through a bankruptcy. I mean, that's something that has happened to her. We have Dave Klemenchik and Dana Grimes, and all of them share one common trait, which is they don't have health insurance, and they don't want the government telling them they have to buy it. Look, we have a lot of members that don't have health insurance because it doesn't make financial sense for them to have it. They think that, look, at the end of the day, I'm maybe going to use $1,000 in medical expenses this year. Why on earth am I going to divert another $11,000, $10,000, whatever it might be, away from my business for these expenses? And I know personally people that they just, they do have savings, and if something catastrophic happens, they can go pay their bills that way. And I would note that, as Nina knows, this law says no more catastrophic coverage. So if we're really worried about the person that's going to get hit by the proverbial bus, why on earth would we outlaw policies that cover just for that? But yet that's what this law does.
Mm-hmm. Next question. First of all, I just want to make sure if this is anyone's cell phone. I found it under here. Okay, good. I just wanted to make sure it wasn't Karen's. Next question.
Hi, I'm Diane Katz with Heritage. I really want to hope that the court's going to do the right thing, but I'm afraid to hope. So what's plan B in the event that we don't get, the right outcome?
Well, I need to excuse myself, and it sounds like a good question for the policy people.
Yeah. Thank you. I'll let our panelists answer some of those questions and pepper in if I feel like I have something urgent to say.
Sure. One of the point I tried to make was that, and I think you probably agree with me, that the policy in the Affordable Care Act is not just unconstitutional. It's bad policy. So even if it did fit within the framework of the Constitution, there's some ideas driving it that are just not going to work. So I would hope that through a congressional repeal effort, I think obviously a lot hinges on the next elections in 2012, depending on who's in charge, who's in control of the Senate, who's in the White House. We could do something legislatively that way. Of course, they've already repealed the 1099 provision, and then the House voted this week to repeal the IPAB, which is a board that would cut payments to Medicare. So there are piecemeal parts of repeal. There's certainly been an effort in this Congress to defund parts of the law, and I wish that Christy Herrera were here so she could talk about the efforts in the states to push back against this law. A lot of state-level statutes have been passed to sort of work against the individual mandate, the State Healthcare Freedom Acts that have been passed in several states. So maybe Nina wants to add in too, but I think there's been such a pushback from the populace, from the public. 72% of people in a recent Gallup poll said they think the individual mandate is unconstitutional, and that includes a majority of Democrats. So I think it's after this particular battle is over, and also after some other constitutional challenges make their way through. The Goldwater Institute has a case against the IPAB that's in a stay of proceedings right now, waiting to hear what happens in the Florida case. There's at least 5 other cases that have been filed just recently because of the HHS contraception mandate. So this is going to continue to go on and on. Wednesday may be the end of the oral arguments, but it's far from over.
Mm-hmm. And following on that as well, Nina mentioned the Nancy Pelosi's comment of we won't know what the law is until we pass it. And honestly, we still don't know what's in the law because there's still these regulations that are coming down just like the HHS mandate did. So while these are the lawsuits we have so far, who knows what the next regulation will be and who it's going to affect, and there'll probably be even further lawsuits on those. So
Yeah, I'd just add 3 quick points. One, I think the individual mandate is really the poster child for this health care law, and people have rallied around it because it is very visible, and people understand it. It's at its core what it's about. I would also say, too, that I think you're absolutely right. One of the things that this health care law did was shift massive amounts of power over to HHS to actually write the law. This wasn't something that was done in a clear, nice package as a Christmas present. It was actually rammed through Congress. And so there are lots of holes that now the Secretary of HHS is going to fill in. And that's why I think the more we learn, the more we will probably be very disappointed in the results of what this administration has in store for us. And the last thing is, I kind of do think it's like a Band-Aid. And you can either rip it off, which is the fastest and easiest, which is what this, I think, event and what this whole idea of full repeal is all about. And we have till next year, I think, to try to get that done. If we are in the same situation as we are today next year, I think it will continue to be more of like the slowly pulling it off. But I don't think the American people are going to stop until they have truly pulled it out by its roots at some point. It may take a while, but we've got to dig our way out of it at that point.
My name is Charlie Kuhn, and I am a former Heritage staffer. And I have actually 2 questions. One's a legal question, and the other is, based on everything I'm reading in the paper lately, in the Wall Street Journal and others, getting up to speed, I'm surprised about a few things. But the legal question I have has been discussed on Mark Levin, and I'm an attorney, so I'm very much aware of what now I can't remember it, proper and necessary clause. Mm-hmm. I know that some people are trying to use that as a catch-all as well. Could you kind of go into a little bit more of an explanation on that? And then the policy question is, I hate to admit my ignorance on this, but I have been surprised at how much of this Obamacare is already in place, and I'm wondering if somebody could tell us how much. I mean, I'm reading, the prescription drugs and the kids. I mean, I knew that, but how much else is already being is enacted and being implemented?
To go to your question about the necessary and proper clause, that has seen increasing amounts of focus from the government. I think it's an indication that they know the weakness of their Commerce Clause argument, because while they may have had a shot at some of the lower courts in getting it found constitutional under the Commerce Clause, I think they know they won't be able to get 5 votes at the Supreme Court with the Commerce Clause alone, because it simply isn't interstate commerce, and it's not regulating interstate commerce to make someone enter the commerce in the first place. So they're taking, in some ways, actually a cue from Justice Scalia, who had said that when we talk about all this expansion we've seen of the Commerce Clause, they weren't really powers that were coming from the Commerce Clause per se. They were really necessary and proper powers. So you're not actually regulating interstate commerce when you're regulating things that someone who's say growing marijuana at home, but you're outlawing it under the Interstate Commerce Clause. It's because it's necessary and proper to be able to do your interstate commerce regulation that you have to have some control over the intrastate.
That's just in the state where the marijuana is being.
Exactly, and that was basically that was what Justice Scalia's point in that particular case, saying, okay, really they can ban the interstate commerce of it, but it's going to be really very difficult for the government to monitor that as long as there's a legal intrastate market. So you can reinterpret some of those cases, as he has, under the necessary and proper clause. And I think that's the shot that the government thinks they have at getting some of these conservative votes. The problem is, I think this is going into an analysis of the necessary and proper clause that hasn't been done as much. We've talked, the cases that have been before, they're all a little bit fuzzy, but they talk about, was it necessary and is it proper? And that's almost a sort of self-referential question sometimes. But what we're looking at here is almost the rest of the clause. It says, the Congress has the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. So is the individual mandate actually carrying into execution any other part of the law? No. it's mitigating other harms to the insurance industry, but it doesn't execute anything. It's just not like, in order to exercise the taxing power, you need to be able to, you have to have the authority to hire tax assessors, you need to have the authority to build a building for the IRS, all these things, which, okay, yes, those are necessary and proper in order to even execute the tax laws. But you don't have to mandate people to enter the insurance market in order to execute all these other powers that we all concede are constitutional, whether or not they're policy-wise good things. So I think that is what it's going to come down to at the end of the day. And again, I hope that that the government is willing to, that the Supreme Court is willing to put that limit back in the Constitution, because unfortunately, I think the liberal justices don't seem terribly concerned about the idea of constitutional limits. You can even see from Justice Ginsburg's recent comments in Egypt when she said the U.S. Constitution wasn't something she'd recommend people to look at. She recommended they look at the Canadian Charter of Rights and Freedoms and look at the South African Constitution, all things which have been written, of course, in the last few decades. I think the oldest one that she cited was 1982. Anything older than that is really shockingly old and we shouldn't be looking at. But the difference between those type of documents and our Constitution is that they just are lists of rights, basically. Mm-hmm. And our Constitution has these structural protections that says you can't do all these other things. Maybe a lot of those things that they can't do might even be good things. But we want to slow down the movement of government so we can have time to check. And frankly, the things that are really good the government might do that are unconstitutional, I think we could probably find private individuals and organizations that will do those same things at some point anyway. So I think that goes to why I'm afraid that the liberals in the court are not going to see the value in having these limits. But
as a non-lawyer, I've often thought of this necessary and proper defense as if the law required us all to wear hard hats. And you think, well, certainly our government can't require us to wear hard hats. But if they turned our entire country into a dangerous construction zone, then they would have to require us all to wear hard hats. It would be necessary to require us to wear hard hats. So I think it's a sort of a silly defense, but I understand it's more nuanced than that. In terms of the pieces of the law that have already been put into place, so far, even though there are several things that have been enacted, like a few insurance industry regulations and reforms, and some new taxes, which, whether or not you've noticed them, are in effect. If you visit a tanning salon, you may have noticed there's a 10% tax on tanning. But there are some new taxes and insurance industry regulations. But importantly, it's important to emphasize that the biggest structural reforms, like the statewide exchanges or like the Medicaid expansion, or the IPAB, the Medicare Payment Board, and the individual and employer mandates do not go into effect until 2014, and that is if they're ready. There's serious doubts as to whether or not all these statewide exchanges are going to be prepared to run, because so many of the states have said, no, we're not going to do that.
Well, that's why I wanted to ask the question, because I knew it was 2014.
2014.
And then I read that some of it is already being enacted and implemented.
Right, and those are, generally some of the regulations, even some of the regulations that we've seen come out of HHS, some of them will take effect before 2014. Maybe Nina wants to comment about that. And of course, the most recent contraception one was given an extra year's worth of waiver so that employers could sort of get used to it.
Yeah. I think that the idea is kind of like the lights go on in 2014, like the party begins, but there's like, if you've ever planned a party, it takes a couple of months to get it up and moving, make sure the vendors are there, everyone's ready to go when the moment starts. So while the provisions, the big ones, don't take effect until 2014, you can be assured that the administration is working behind the scenes to kind of get the hard wiring moving. And that's really where the regulations come in, and a lot of the kind of concern of, can they meet the deadline in time? Are the lights going to turn on when they turn the light switch on in 2014, or is this all going to kind of fall at its own weight? I think either way is a dangerous kind of future for us. If the lights come on, we're in real trouble. If they don't come on, yes, it shows that the law itself is almost unworkable in its right, but that doesn't mean that the law isn't gone. We do have a paper that just came out this week called the 2-Year Checkup, More Reasons for Repeal, and it actually goes through some of those kind of the sundry of provisions that are in existence today, and kind of gives an update on where they are and whether they've been effective or not. And all in all, they've been ineffective and continue to just show that this is unworkable. So
Right.
You may
And
want to take a look at that.
on paper, I'll add that the provisions that are in effect, like the rule that anyone under age 26 can be on their parents' insurance, or some preventative care measures, like you have to include mammogram coverage, or that children cannot be denied insurance because of their pre-existing condition, all these are the most popular parts of the law. And the people who wrote the law and designed it did it this way on purpose because they realized 2012 is an election year. Who knew? And so these pieces that are already in effect are the parts that groups on the left and supporters of the people who passed the Affordable Care Act can tout as saying, look at what we've done for the American public, and it might get a mention in the State of the Union address. Now young people can stay on their parents' insurance, and let's move on from the health care topic because I know how unpopular this is with the public. So the pieces that have been implemented that are currently in effect are the most popular parts.
On which one?
Well, just regulations in general. Right?
Yes,
Normally, okay.
They have. As they trickle out on a Friday afternoon at 5.
Yeah, universally
Yes.
Friday afternoons.
Oh, yes, one more question.
My name's Frida Hadley. I'm a member of one of the Women's Republican clubs. From what I read about it, it's not good for the seniors, and also it's giving the government the right to go into your bank account for certain things. And how can we afford it if we're in so much debt now?
Good question. You should be on the panel with us. You're pointing out exactly the things. On the seniors, just a couple of things that is exactly right. The one thing I always like to point out to people is it was this health care law that kind of changed Medicare as we know it today. And if you recall, the administration took $500 billion out of Medicare, not to shore it up. We know it's going bankrupt in the future. But instead of using that savings to kind of shore up Medicare, they took that $500 billion to expand a Medicaid program and give new benefits to the working population. That is a big difference of what we think we need to be doing on the case of Medicare and on health insurance altogether. And on the point of the bank accounts, I'm not clear on that. I do know that it's been a concern of what it is, but a $2 trillion price tag, I mean, I don't know. I didn't know that we had that kind of money rolling around. You know, people say money grows on trees, but I haven't seen it around Washington. They think there is. So
trees
I think
in China.
we have a big
Money
problem.
grows on trees
That's
in China.
right. That's right. That's what a tree is. That's why we need to go.
But
there.
again, with the cost estimate, they front-loaded the law. You know, what we had with the original estimate was a 10-year estimate for 10 years of revenues. But the big spending didn't kick in until 2014, so there were essentially 6 years of spending. And the original CBO estimate looked pretty good. In fact, it was deficit neutral, right? Didn't we hear that a few times? But it turns out that when we get closer, when we start including more of the spending years and not including more of the revenue collection years, we actually see that the cost has almost doubled in terms of the CBO estimate, the most recent one at $1.72 trillion. And about the bank accounts, I think one thing that's important to realize in terms of these statewide exchanges is that the exchanges, in order to deliver these subsidies, will have to monitor your income and health insurance status in real time. And that's one of the reasons that people doubt whether or not the statewide exchanges, if states refuse to implement or build or create one, then the federal government has said, well, we will do it for you. We'll come in and do it for you. But there's between 20 and 30 states that have said, we're not going to do this, or we probably won't do this. And it's very questionable to me whether or not we have the funding or the resources at the federal level to go into these half of the states in the union and set up an exchange that will monitor the income and health insurance status of every citizen of that state.
Absolutely. I think that, just in closing, I don't think the American people were fooled by this health care law, and I think that's encouraging. I think, we're not in the minority. We're actually in the majority on this, and I think that as we have seen, not just, as Bridget said, this isn't just about health care anymore. This is about the role of government in our lives. And I think the American people have seen that they don't trust Washington, and this is just the perfect example of why we need to restore back to what our country was founded on. So let me bring up Michelle and Bridget to close us out.
What an excellent discussion, ladies. I'm Michelle Easton, co-host of this with Bridget and Becky. I've been doing this for 10 years, and I've never been late before today. So please forgive me. Unbelievable crowds of people out around town. But what a great discussion. I can't think of any more critical issue right now affecting all of us, our children, our families, and our country. Wouldn't it be nice if the court just repealed it. And then our lives would all be so much simpler. But if that doesn't happen, certainly this discussion is going to help all of us in the days ahead. And I want to thank you all so much. And I have some gifts for you. We have...
Aren't you glad Michelle made it back?
Yeah, Santa Claus.
Our Great American Conservative Women Calendar. You have to have one of these. All these ladies speak for us. We have our Clare Boothe Luce Policy Institute.
Whoa, that was me, not an alarm.
I hit something.
You pass that down.
Yeah.
And we have a new limited edition coffee mug. You are among the first to get it in our purple from our website. With the very famous saying from Clare Boothe Luce, no good deed goes unpunished.
Yay!
And my penance for being late today is a coffee mug for Bridget.
Fabulous.
And one for Becky, too.
Fabulous. Thank you so much. We'll give you our heritage gift outside. It's our Heritage Guide to the Constitution, how appropriate. For those of you in the audience who don't have one, you can check in with us and we'll tell you how you can get a copy of your very own. And just this next month, we're going to have an online version of the Heritage Guide to the Constitution that'll be searchable. So we'll be sure to have a card at our next meeting so that you all can bookmark that address. We've got a couple of items out on the table outside with our lunch. These little palm cards Pam used, thank you very much, from the Heritage Marketing team who put these together. We're going to hand these out at the rallies this weekend. So if you're going to a rally and you'd like to get a stack of the cards to pass out for yourself, or make sure your local Tea Party has copies of them, come to us and we'll supply you. And a couple of our most recent papers, I think one of them that Nina referred to, are out on the table as well. So thanks again for joining us. We hope you'll be following the debate as it continues and the Supreme Court decision. Follow the Heritage blog. We're going to be blogging on the court case and the arguments. And thank our panelists and join us for lunch afterwards. So thank you again.